Hello and welcome to the second part of my lecture on registered land. If you haven't seen the first part yet, then do check that out. Otherwise, we're just going to jump straight in and get started with part two. In the first part of the lecture, we talked about different things that can impact a buyer, and we focused on registered charges and interests that are safeguarded by a notice in the register. In other words, we focused on things that were actually entered into the register for registered land, because the idea is that this register should reflect the reality surrounding the property. However, in this second part, we're changing it up a little bit because we're focusing on unregistered interests that nevertheless override registration. And this is a bit unusual because while the register should reflect reality, we're looking at situations here where something is not on the register and yet still has priority. This does have its foundation in law and was retained by Section 29 of the Land Registration Act 2002, and these unregistered interests can still take priority even if the buyer does not know that those interests even exist. The reason that we have this situation, and it is slightly unusual, is because of the social importance of doing so. If we didn't have it, then it's possible that people might be kicked out of their house without warning for no fault of their own. However, the buyer does have the opportunity and has to discover these interests through inspecting the land themselves. In other words, if something is not on the register, it's only by inspecting the land that they're buying that they will discover these unregistered interests. Now, overriding interests are a little bit controversial because obviously it goes against the registered land system. And so the Land Registration Act 2002 reduced the number of overriding interests, and also made some of the interests that were previously unregisterable registerable. The possible future of this area, especially if you're thinking about doing an essay, is to look at e-conveyancing, because the idea of e-conveyancing is that almost everything at that point should be registerable, and so there would be no unregisterable interests left that could override something that is on the register. There are main categories of overriding interests that are listed in Schedule 3 of the Act. These are legal leases of less than 7 years, local land charges, particular legal easements and land charges, and also the main one that we're going to be focusing on today, and that is often the focus of problem questions in this area, which is the proprietary interests of those in actual occupation. So how do we actually work this out? Well, we can have a formula that is essentially derived from the wording in Schedule 3, paragraph 2, and this is where there is an interest and actual occupation without an inquiry, then we are left with an interest which overrides. We can break this down a little bit further and we'll look at the different aspects of this formula so that you have a better idea for approaching this type of question. So what types of interests are protected? When we talk about interests within that formula, what are we actually talking about? And we're talking about proprietary interests here, so not personal interests, but proprietary interests that are actually linked with the property itself. And I've put a few examples down here. It's not a comprehensive list. If you do want a comprehensive list, then I'm sure there's lists online or most likely listed in your textbook, but these are some of the main focuses. We've got legal leases and tenancies. Some of you may remember the Ashburn Anstalt case from the end of the last lecture. Equitable leases and tenancies. Beneficial interests under a bare trust, and that's from the famous case of Hodgson and Marks. And beneficial interests under some other trust of land. And Williams and Glynn's Bank is a very famous case, and we'll come back to it later and explore that case in further detail. So that's probably the most common. There are also some statutory interests that are protected. These are rights to preemption under Section 115 of the Act, and also under Section 116 there are various things to do with minor equities that are also interests for the purpose. But as I say, it's not a comprehensive list, but that should give you an idea about the types of proprietary interests that can be protected. What about this inquiry that has to be made by the buyer itself? We've talked about this a couple of times already. Essentially, the buyer, before they actually buy the property, must ask each of the individual occupiers what rights she or he has in the land. And once the person answers that question, they are in a position to ask for those rights to be waived. So essentially, it's just an inquiry process where the buyer asks the actual occupiers, what are your interests in this land? Once the actual occupier is asked this question, they have to respond fully, else they lose those rights when it comes forward. So that's the importance of the inquiry. There's responsibilities by both the buyer in asking the question and also the actual occupier in answering the question to the best of their ability to do so and giving full disclosure. The most complicated area of this is actual occupation, though, and there are a number of factors that count towards what is actual occupation. How can we actually define it? It can vary depending on the premises, and it doesn't have to be the entire premises, it can just be one part of it. More than one person can be an actual occupation, and it does not have to be adverse. So we're not talking about people squatting on the land here. It can be that the actual occupation is allowed by the current owner, and that was the case in Williams and Glinsbank and Boland, where the actual occupier was the wife of the owner itself. The actual occupation, according to the Act itself, paragraph 2C2, is that it has to be obvious on a reasonably careful inspection of the land at the time of disposition. And there are two factors to take into account here. Firstly, the actual occupation has to be obvious, and it also has to be obvious at the time of the disposition. The occupation as well can be vicarious, so via an agent, someone representing the actual occupier. That was the case in Lloyds Bank and Rossett, or by a relative who is acting in the stead of the actual occupier, and that's from Strand Securities. Other ways that actual occupation can be discoverable through an inspection of the land are possibly symbolic ways as well. So we can talk about furniture being present in there. That would be obvious that then someone is in actual occupation. That was the case in the Chocar case from 1984. Or if there's been recent construction on the land, that might then again be an obvious sign that someone has been in actual occupation or is in actual occupation, as was seen in Gudger and Willis from 1999. I think that the best way to approach this when you're dealing with a problem question is to think about, would it be obvious to me in a common sense sense of the word that there is a person living in this house, that there is someone who is in actual occupation? If you go there and you find that there's a bed and furniture and they've got food in the fridge, then it's pretty obvious that there is someone living there. And that's the way to try and approach those questions, although obviously you want to also use case law to back up that common sense. A few other factors as well. So there has to be some notion of continuity. So it has to go over a period of time, the actual occupation, and beyond a mere fleeting presence, as in Abbey National and Cannes. So you can imagine situations here where someone might live in the property, but only for 1 week a year, and the rest of the time they live in their second home in Antigua or something. That might be actual occupation for that week, but realistically it's not actual occupation for the purposes of the law, because it's really just a fleeting presence and there isn't any notion of continuity there. Obviously, though, there is the other side of this equation where temporary absences are allowed. So if someone pops to the shop, it's not that they lose their actual occupation, because their furniture is still there and they still have food in the fridge, and they're probably going to come back to that property once they've finished doing their shopping or something. That's obviously quite an extreme example, but it does show that actual occupation does allow for these temporary absences. And that might also include someone going on a 1 week or a 2 week holiday or something like that. It's only really a temporary absence, and the intention of the person is to return to their home. A couple of final points on actual occupation. There's no occupation of an easement, so a right of way. You can't occupy a right of way by definition. Children cannot be an actual occupation, and this is quite interesting because it dates back to a time when the occupancy of wives and children was seen as being just a shadow of the owner. Now, obviously, nowadays, wives can be occupiers in their own right, but children's occupation is still being still seen as a shadow of the owner's occupation itself. Finally, you cannot use the corporate veil for actual occupation, and there's a case there for you for that. Now, well done if you've survived until this point, because the main focus of problem questions in this area tends to be around trust interests, which are overriding interests. And so this is going to be the main focus for the last part of this lecture. And the real question that we're asking here is what actually happens when a single owner disposes of registered land to someone unaware that the land is held on trust? And this creates a sort of problematic situation, because you have a buyer who feels that they've got legitimate rights to the land, they've bought the property, they've gone through all of the formalities, and they should be allowed to just take possession of the land itself. And on the other hand, you have other people who have trust interest in the land and might be actual occupiers, and they're potentially losing the roof over their heads. So you have two conflicting interests here, and it was up to the courts to decide who should win out in the end. And as we talked about earlier, ultimately this came down to a sort of social construction of the law and not wanting people to lose the roof over their heads. So if a wife, as in the case of Boland, or someone else who is living in the property and has an interest in it, if they lose the property through no fault of their own, then they would have the rights. And so we have this famous case in 1981 that says where there isn't an inquiry, the beneficial owner in actual occupation behind an implied trust of land has an interest binding those who deal with the sole registered proprietor of that land. And this is really important, although it did attract a lot of criticism from people, in particular banks, who were trying to sort of maybe foreclose on mortgages, or other people who had an interest in buying land, that this was a disruption on the property market and that they couldn't really be certain about the property that they were buying if there were these overriding interests that they had to be aware of. And so what we have seen happen since 1981 is an erosion of the Boland principle, or the Boland decision. And so we have things like City of London Building Society and Flegg from 1988, which basically says that a disposition by two or more trustees overreaches the overriding interest. In other words, what we had in Boland was a single person selling the property. But if we have more than one person selling the property, then this will overreach the overriding interest of those in actual occupation. Furthermore, if the beneficiary, in other words the actual occupier, has knowledge that the owner is selling the property, then they may be stopped from enforcing their overriding interest. So it basically has to be a bit of a surprise to them that the property is being sold. That's from Ulster Bank and Shanks. A couple of final principles that we can look at. There's the exclusion of acquisition mortgage transactions, so people who are contributing to the purchase price of the property, they may lose their rights. And even if there is a successful overriding interest, in other words, a replication of Boland, then someone like a bank or someone who buys the property could apply to have the property sold via a court order, and so they would still be able to realise their potential value in the property even where there is an overriding interest. And that concludes registered land. If you're answering this as an essay question, then you want to do a balance between the advantages of having the certainty of a registered land system where everything is recorded in one place against the social benefit of having unregistered interests that can override registration and help people to keep a roof over their heads. As you move forward into the future, you might want to also consider e-conveyancing as well, and how that can make more interests registerable and increase the advantage of having a registered land system. If you're answering this as a problem question, then you want to focus on that formula that we had on the slide earlier on. In particular, thinking about how a proprietary interest in combination with actual occupation without an inquiry from a buyer can lead to an interest which overrides. Looking at all of those and putting them together and using the appropriate case law can really help you to achieve a first-class grade. Well, thank you very much for watching. If you do have any questions, then leave those as a comment below. Make sure to give the video a like and subscribe for more videos in the future. Thanks very much for watching.
Bye.